Morning. This is the CEDAW People's Tribunal, the Convention on the Elimination of All Forms of Discrimination Against Women. We're sitting on the 13th of July 2022 on the issue of women's pension rights. The CEDAW People's Tribunal sat for 3 days in 2021, from the 21st to the 23rd of June, hearing from witnesses testifying to the disparities and the discriminations impacting on women through the public and private sector by reason of government policy and through laws, statute law and common law, in formal terms and in practice. Evidence was given by women and men, professionals working in the private sector, academics working in universities and research institutes, women working in grassroots services providing information, advice and support to women. This evidence confirmed that discrimination on the basis of sex and gender is inherent in the status of women in this country, as it is inherent in the status of women throughout the world. Black and minoritized women, women with a disability, women of mature years and aging women, young women and girls, and women in their 20s and 30s seeking to fulfill themselves through advancement in a career, whether it be a trade or a profession, a small business or a corporation or a larger business in the business world. It does not matter who she is, her background, the advantages she may have through class, family background, nationality or citizenship. Women as a class suffer discrimination in education, employment, in services and accommodation, in language and in the law, as students, as workers, as consumers, as rural women and farmers, as women who are retirees or voluntary workers, or both, as daughters, as wives, as mothers, as single, divorced, or widowed women. Intersectionality, the combination of sex and gender with race, ethnicity, cultural background, disability, adds to the discrimination. It adds dimensions to the discrimination. The CEDAW People's Tribunal concluded by the President's report of August 2021 that the United Kingdom must implement its obligation to introduce a Women's Bill of Rights consistent with the terms and provisions of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. That undertaking was given by ratification of CEDAW by the United Kingdom government in 1986, following the signing of CEDAW in 1981. The United Kingdom government entered into the optional protocol to CEDAW in 2004. But it has not adopted CEDAW domestically, despite its undertaking to do so, and to honour by bringing into law the provisions of CEDAW and the general recommendations made under CEDAW by the United Nations CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women Committee. The CEDAW People's Tribunal sits again today on the 13th of July, the year 2022, to address one of the most compelling reasons for women's demand for a United Kingdom Women's Bill of Rights. CEDAW Article 3 states, states parties, of which of course the United Kingdom is one, states parties shall take all appropriate measures in all fields, in particular economic and cultural fields, measures including legislation to ensure the full development and advancement of women, to guarantee the exercise and enjoyment of human rights and fundamental freedoms. CEDAW Article 11 provides that such measures are essential in regard to equal remuneration, including benefits, and to equal treatment in respect of work of equal value and equality of treatment in the evaluation and quality and the value of work. How much is work worth? How much is women's work worth? How much has women's work been devalued relative to men's work? Article 12 refers also to women's right to health and well-being, vital also to today's hearings. As a backdrop also to this issue, General Recommendation number 17 of 1991 affirms as well that all women's work, paid work, as well as unremunerated work, unpaid domestic work, is vital to the gross national product too, although this has never been properly recognised nor acknowledged in or by the United Kingdom. This background is a necessary introduction to today's proceedings. The CEDAW People's Tribunal will hear from witnesses testifying from varying perspectives to the indignity and denial of economic rights visited upon women born in the 1950s in regard to their pension entitlements. So why specifically are we here today? Almost 20 years ago, the United Kingdom Parliament passed the Pensions Act of 1995. This act increased the state pension age for women from 60 years to 65 years in stages between May 2010 and March 2020, so that pension accrual dates for women and men would align. Traditionally, under the law, men gained eligibility to state pension at 65 years, whilst women gained eligibility for state pension at 60 years. This appears to have been centred in culturally traditional stereotypes of women and men and their roles and functions in society. It may have been considered that setting the retirement ages at this male-female differential would mean wives and husbands would reach the state pension retirement age together. A notion that women marry men roughly a few years older would mean the wife would retire at 60 with the state pension, readying the household and home base for her husband's retirement a relatively short time thereafter, with his state pension right at 65. Well, whatever the motivation, however based in stereotyping, by the time the Pensions Act of 1995 was in drafting, we must save money imperative conveniently joined forces with the proposition that women and men should be equal. Equality in this regard was seen as ensuring that rather than women's state pension retirement age remaining at 60 years and unequal with men's, it should be raised incrementally to equality with men's, so ending up at 65 years. Well, certainly this formal equality could have been arrived at by deeming the state pension retirement age as 60 for both women and men. But that, of course, would not have agreed with the save the money imperative driving this change. This levelling up is so often the crudest and cruelest of tricks in the panoply of equality measures, where equality is deprived wholly of its meaning in human rights terms. Is this the case here? We have a situation where formal equality is introduced in absolute ignorance of the need for substantive equality. The Pensions Act of 1995 and the Pensions Act following of 2011 has increased the state pension retirement age of 2.7 million women in the United Kingdom. 2.7 million women who have been impacted by the introduction of so-called equality on paper, whilst denying entirely the essence of true equality, which must engage with substantive equality. And so now we've come to the final remarks in relation to our CEDAW tribunal, our CEDAWinLAW Tribunal. We've heard today from a number of witnesses from a number of perspectives. This morning, we heard from Leanne Dallimore and also from Michaela Hawkins, both of whom are members of the union Unison. And they spoke about the impact of the changes that were wrought by the Pensions Act of the State Pensions Act of 1995 and 2011 in terms of their membership and upon them as individuals, them personally. They spoke about the number of motions that Unison has put forward to address this issue, and the activism of the women within the union movement who are cognizant of the problems that relate to women in the paid workforce and in terms of industrial conditions, the pay gap, which has led to the pensions gap, which has been acted upon incrementally by the changes to the pensions and the age at which the state pension becomes payable. We've also heard from Carol May, Pauline Hinder, and Dr. Shirley Presser. Each of these witnesses spoke about the personal impact that she suffered from these changes. All our witnesses this morning spoke about the fact that there was little or no information provided by government about these changes. An act went through Parliament, that's correct. However, women were not notified. And when they were notified, like Pauline Hinder, when she wrote to get the information, she received a booklet with a cover letter. The cover letter did not state what the changes were or that there were changes. She had to go to a page number 5, as I recall, of that booklet to find any reference at all to this significant change, this huge economically impactful change that she and other women born in the 1950s would suffer and are suffering. Carol May spoke about the impact on her and how it led, both she, Pauline Hinder, had also gone through divorce, as had Dr. Shirley Presser. And this, of course, has if I might put it in colloquial terms, a double whammy impact, because there's the impact, it's triple whammy actually. There's the impact of the unequal pay and the impact that that has on building up pension entitlements in any event. Then there's the impact of the 1995 and 2011 State Pension Act issues, the impact. Then there's, for those who go through divorce, there's the divorce impact and the failure of the family law to actually acknowledge the real contribution that women make in a marriage partnership. And here, the state pension is vitally important because the pensions that the male partner is building up will be far higher, generally speaking, even if the women are professional women working at relatively high levels. Of course, any woman that's a professional woman working at a relatively high level, I'm afraid, because of the so-called glass ceiling, will not be working, generally speaking, at the same high level as the male confreres, and the pay gap will still remain because of other discriminations within the paid workforce and because of discriminations in the society in general in relation to childbirth, in relation to pregnancy, in relation to maternity, in relation to time out from the job in order to do the initial childcare relating to any children that any woman has born. So they spoke about those aspects. Now, following the luncheon adjournment, we heard from David Hinkie, who is an investigative journalist who runs a blog that has been covering the issues relating to women, 50s women who've been impacted by the changes to the State Pension Act of 2011 and the State Pension Act of 1995. And he gave extensive evidence about his researchers and what they had disclosed in relation, for example, to the failure to inform, in relation to the regrettable judicial review effort, in relation to other efforts that have been taken and the limitations of those efforts, such as the Ombudsman and the Department of Pensions, Work and Pensions. And we've just heard from Dr. Elgin Safarov, who gave us the international perspective on CEDAW and its application in this country, as he is the Vice Chair of the CEDAW committee that overlooks the implementation of CEDAW. So coming to some final remarks, if I may, I want to ask several questions. First of all, in this issue, we need to ask, are women and men equal? We ask, do women and men enjoy equality of economic, social, cultural rights? Are women and men equal in status and in law? Do we need a Women's Bill of Rights? CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, says yes. And this country has actually said yes in signing CEDAW in 1981, in ratifying CEDAW in 1986, which says an undertaking is made by this country to adopt CEDAW domestically, together with the general recommendations made by the committee, the CEDAW committee, which operates in relation to CEDAW. Now, if we calculate 1986 up to the present time, 86, 96, 106, 116, then we get 86, 96, 106, sorry, and 116. We come to the grand total of getting on for decades where we've undertaken in this country to implement CEDAW, and yet what has happened? It has not been done. Some steps have been taken. We've got the Equality Act of 2010. But it's not sufficient because it does not incorporate all the provisions of CEDAW, which are absolutely essential to the rights of every woman and girl in this country. And of course, if CEDAW is implemented, it will benefit ultimately not only women and girls, but it will benefit the whole of society, including boys and men. Because as long as we live in a society where there is no equality for women, where there is no equality between women and men, then we live in a society that is not operating to its optimal degree. And we are missing out on the talents, on the abilities of women being recognised properly in the society. And if we come back to this issue, in terms of remuneration and thus in pension rights. So in 1970, the Equal Pay Act was passed, yet women do not have equal pay, as has been attested to here today. In 2010, the Equality Act required gender audits of departmental budgets before they were set. This is honoured in the breach, as the Fawcett Society discovered in relation to the Coalition Government 2010 budget. Although the 2010 austerity budget, as it was called, impacted differentially upon services for women, with cuts to general services designed and operating so that women lost out to men too, the Fawcett Society's judicial review application failed. Basically, the court said it was too late. The budget was now in place, cuts had been made and were continuing at a savage pace. Women were suffering targeted disadvantage, but the court could do nothing, they said. Women faced a fait accompli. The Equality Act provision that the budget should have been reviewed before it was finalised for its gender impact. That provision counted for nothing. And it seems somewhat prescient that when the 60s women judicial review went forward, same thing. The court said, too late, fait accompli, it's already been done, and women simply had to, in colloquial terms, wear it. Well, in 1991, the House of Lords decision that rape in marriage is a crime came extremely late in the day, but nonetheless, it reversed a nonsense notion that had existed in this country because the Chief Justice of England, Chief Justice Hale, in 1640, and then published in 1736, said rape in marriage did not exist. Subtext, if it did, too bad. It's not a crime. Sitting on the last trial of witches in this country, Hale declared that he knew witches were real because his court had just found that they were guilty and therefore they were in his court. And anyway, the Bible affirmed it. This was conveniently overlooked, however, when his diktat was called upon to assert that no marital rape existed, or if it did, no husband could be prosecuted for it. Next, following earlier reforms, the 2003 Sexual Offences Act was supposed to fix rape law with clarity about what constitutes the crime, including definitions of consent. Yet women and girls continue to be raped almost with impunity, and the focus on consent turns the trial into a trial of the principal witness, the complainant, so-called, rather than focusing on what's gone on in the man's mind, what's gone on in the mind of the accused, what's gone on in terms of his conduct. In 1967, the Abortion Act was passed to provide some certainty for women and their medical doctors that termination of pregnancy could be addressed as a health issue rather than women and practitioners being targeted by the Offences Against the Person Act, a law passed more than 100 years before in 1861. Those provisions were repealed in 2019, enabling Northern Ireland women to escape criminalisation for this health treatment. Although, unfortunately, the health treatment is not sufficiently available in Northern Ireland, at least if it is, it won't be criminal, because the Offences Against the Person Act provisions were repealed, as I said, in 2019. However, in England and Wales and Scotland, when it comes to the issue of criminality, the 1967 Act applies. It never ever applied in Northern Ireland. That is why Northern Ireland is in a position of having no criminal provisions apart from ordinary provisions that would apply to any medical operation intact. Under the Abortion Act in this country of 1967, abortion is legal but must be carried out under specific strict circumstances and must be attested to, be authorised to, in accordance with those provisions by 2 medical practitioners. What other medical operation has this requirement? One can certainly make an argument of sex discrimination in that regard. And then once the abortion has been carried out, the doctor must send a report to the chief medical officer, whether it's England or Wales, wherever the operation is carried out in this country, apart from Northern Ireland. The report goes to the chief medical officer that the woman has actually had an abortion. Again, what operation is covered by such a requirement? And then Section 5 of the Abortion Act makes abortion illegal if it is not carried out in strict terms of the Abortion Act. And therefore, we need to review this in terms of women's rights to medical treatment as a health matter. No other health provision is subject to such violations of right to private consultation with one's doctor. Witnesses before what was the CEDAW People's Tribunal in June last year outlined many injustices confronting women in the legal system and their daily lives. Black and minoritised women denied services, their entitlement as equal human beings with equal rights. Discrimination experienced by women generally compounded several-fold, and this follows for women with a disability, women who are older women, and women who are living in rural areas, etc. And we therefore, that tribunal, in the President's report, concluded in accordance with the evidence presented for it that a Bill of Rights, a Women's Bill of Rights, is a necessity. I conclude this tribunal, this CEDAW Tribunal today, CEDAWinLAW Tribunal, on the issue of women's pension rights with this provision, that I will write a report. A report will emanate from this CEDAWinLAW Tribunal on the rights of women in regard to pensions, and most explicitly in regard to the 1950s women who have been so badly impacted, as the evidence indicates, by the 1995 State Pension Act provisions and the 2011 State Pension Act provisions. What we need to conclude by saying is that, consistent with the call of the witnesses before the CEDAW People's Tribunal in 2021, and consistent with the call consistently from each of the witnesses in this CEDAWinLAW Tribunal, the campaign for a Women's Bill of Rights must continue, and the campaign for the Women's Bill of Rights will continue under the CEDAWinLAW Tribunal, the CEDAWinLAW campaign, in order that women's rights can be properly recognised and affirmed in this country, consistent with the signing in 1981 of the CEDAW Convention, the ratification of the convention in 1986. I end by saying thank you And thank you to all the witnesses. Thank you to the tremendous support in the background. Thank you to Anne Fenner for introducing each of the witnesses. Thank you to those others in the background whose names I shall recite in my own head, but I know that they, in their modesty, prefer not to have names mentioned, but their names will be affirmed in the report that comes from this CEDAWinLAW Tribunal on women's pension rights, on the 1950s women and their pension rights, their entitlements, and their entitlement to be regarded as human, as humans with dignity and an entitlement to rights, pension rights, and all the rights to which women are entitled. Thank you.